Very good afternoon, everyone. Welcome to today's uLaw webinar. Today's webinar is going to be on Law Office Client Management, or otherwise known as the Contact Management 101. Today's webinar has been accredited for 1 hour of professionalism CPD credits in the provinces of Ontario, British Columbia, and New Brunswick. Once again, the title for today's CPD webinar is Law Office Client Management. And I kindly request you to mute your phone lines and use the chat window at any time to ask any questions that you may have with regards to today's webinar. Like every other uLaw webinar, today's webinar has a very specific agenda. We're going to talk briefly about the client intake process, the client intake documentation that goes behind that process, and the documentation that is required by yourself or your firm to be readily available to present during a law society audit, what we call as the compliance set of documents. So we'll definitely cover the compliance documents after the client intake process has been completed. Briefly share about group management, which is a very interesting topic really for you as a legal firm or a law firm to be able to better organize your clients for both of ease of search as well as ease of retrieval of information across your firm. We'll talk about how best you can handle conflict checks, and one of the more important subjects for today is around how you manage non-engagements, the different templates and documents that you have using practice management tools or templates that you otherwise already have to provide non-engagement and the clarity around non-engagement, which is a very important, I would say, sidestep from a typical client management, contact management perspective. We'll briefly also touch upon ghost clients when we're looking at contacts and conflict checks. Okay. Of course, looking at the law society's requirements after you've done that client intake, simple things as client ID verification, ensuring that you have a very thorough retainer letter or authorization letter depending on the nature of the legal matter. Source of contacts, which is one of the examples that we wanted to present, which is an important document from a law society standpoint to ensure that you're more than a marketing firm that provides leads to other legal firms, or if you're actually a legal firm delivering that legal work. It also works out to be a fantastic marketing document because it pretty much gives you the information about where are all your leads or source of contacts, if you will, are coming from on a periodic basis. Briefly touch upon the ability for you to generate analytics around a client, making it easier for you and your firm to serve that client, and any other documents and letters and client-facing collaterals or letters that you as a legal firm may be generating, and we'll cover some of the best practices around how best to deliver a phenomenal user experience as well as a branded experience during those correspondences. Now, in our previous webinars, we've covered one of an important topic called Everything Practice Management. You can certainly look that up on our YouTube channel. It's called Everything Practice Management, and it's about an hour and a half of professionalism CPD credits as well, where we pretty much cover 7 important professional obligations of a legal firm when it comes to the obligations that they have with regards to client intake, file management, financial management, etc. Right? So today's topic was really to focus on that first step or that first obligation that you have as a legal firm, which is really around client intake and all the pieces of information and documentation that you as a legal firm would then have to follow through and use as a support to help not only the client have a better understanding of the boundaries of the legal representation. Also, for you as a legal firm to then translate that as supporting evidence and documents to the Law Society when you're being audited and being asked for that information to be presented. A good example of that is when you did that client intake, typically a question that's being asked is, did you conduct a conflict check? Did you make sure as a legal firm that it was completely okay and there were no conflicts, or you were aware of the conflict situation before you created a file or a matter for that client? Because you don't want that situation to come back and really reflect upon badly on the firm at a later stage, right? So it's really important that you do conduct that conflict check up front. Depending on the nature of how that conflict check is rendered, then you as a firm have, of course, the power of either moving forward with legally representing the client, in which case you then move on to the next phase of that client intake process, which is the retainer letter. The retainer letter, of course, is a great way for you to document and establish the rules and boundaries of that legal representation. A well thought out retainer letter clearly articulates the responsibilities and the obligations not only of the legal firm, but also of the client, ensuring that they completely understand the timeline with which you expect them to correspond back, the timeline with which you expect them to make payments, whether that's trust or general related. So when I talk about trust payments, I'm talking about retainers and retainer top-ups, right? Establishing clearly the risks, rewards of the different types of correspondence methods that you as a firm are going to be using. Of course, in today's day and age and with the current situation that we're all in, electronic communication has just become a standard way of doing that. You're starting to see legal firms using, online tools such as WebEx or Zoom to also conduct initial client intake, also conduct interviews, have correspondences, conversations. So the new retainer letter needs to certainly reflect this change that has been thrust upon us, right? So it needs to be modified so that you are very clearly articulating the risks and rewards of using, let's say, a Zoom call to have that conversation with your client. And a very important segue of that retainer letter would be ensuring clearly you've articulated the collateral or the fee structure, if you will, if your legal firm has decided to go ahead with representing. Okay, so the retainer letter is one path out of that initial conflict search. The other path, and we'll get back to the retainer letter in a second, but the other path, of course, would be where you conducted the conflict search and you determined for whatever reason, maybe there was a conflict in representing this client because you've already, represented maybe another family member or someone else, whatever the situation may be, and hence you determine that there is a conflict, and you as a firm have determined not to legally represent this client. Then it's still an important obligation by a legal firm to have sent out a correspondence, whether that's mail, email, whatever that correspondence method may have been, to have clear documented evidence that you have sent out that correspondence to your client. It helps, of course, if you can get an acknowledgement. That helps always, making sure that if there's a signed document from both ends. Very important. And that is a very important client intake workflow process document. That is a compliance document that the auditor may ask you for. Okay? So now going back with the other workflow path of not being a conflict, going forward with the retainer, clearly articulating the roles and responsibilities. Okay, so it really starts with that client intake form, entering the information, digesting that information, making a determination based on a conflict search that pretty much needs to do a thorough job of looking at all the information you have within your firm and then determining which path to take, and both these paths have, I would say, compliance-related documentation that goes behind to ensure the safeguardedness of your firm, to make sure the sanity and the importance of these paths are well documented and corresponded to the client. Of course, we briefly touched upon this. There are different documents. There are certain names given to these documents, but really reflecting the nature of what these documents reflect, such as a retainer letter. We spoke about this briefly, so I'm not going to touch too much about it. But most importantly, the nature and scope of matter, client responsibilities. And as I mentioned, a quick change to today's day and age is the advent of technology and using Zoom meetings. Even real estate transactions could sometimes be using different types of these online tools. We've heard now that real estate lawyers, of course, use, whether that's Microsoft Teams, could be WebEx or Zoom meetings, corresponding live that is actually recorded. That becomes an important responsibility now for the legal firm to document this in their retainer letter saying, hey client, I hope you can appreciate and acknowledge, given the nature of the COVID situation that we're all in, we're going to be utilizing this wonderful technology to still facilitate this legal correspondence and transaction. Real estate is a great example of that. Or it could be a conversation, a consult. Of course, the way old technology of using the phone always helps, but a phone call was always followed up by an in-person consultation or a meeting, or law offices were open to invite customers. So if you're in a situation where you're not yet ready to facilitate that and you're doing this online, that now needs to be in that retainer letter, something for you to think about. And that goes back to the final point here, which is the risk associated with the method of communication. Okay? And, of course, going back to the privacy concerns that the client may have. So let's say the client intake process is done. You've entered all the information. You've done the conflict search. You've got all the related information. This is something that the auditor is probably going to ask you for as part of that compliance nature of the client intake. For example, you may be asked randomly to provide information or proof of how you ensured that this client was truly who she or he was saying that they were. Very simple, client ID verification documents. So do you have a scanned copy of their driver's license, their passport, whatever information that you may have used? The Law Society also provides you with certain guideline documents, such as the client ID verification document, that allows you as the legal firm to quickly check off important pieces of information already provided in that form. And we'll touch upon that briefly later on today. That by itself is self-explanatory. So when the auditor does ask you for that, you can very clearly just pull out that document, have it filled out, have, of course, the scanned driver's license available as well. But that client ID verification document by itself should answer any questions that the auditor may have, because it's very much in compliance with what's expected. That particular document itself clearly articulates the information of the client. What specific ID did you verify to confirm the identity of the individual? Or if this is a company, what document did you use to do the same? And did you actually go ahead retaining the client? Or did you see conflict and did you not engage the client? Did you pass that information to another attorney? So that single document pretty much explains it, and that by itself is a great supporting document from a compliance standpoint. Of course, then there's the retainer letter or the engagement letter that then follows that. You've done the client intake, you've got all the necessary documents that you need, you assessed it, and you've moved forward with the case, and now you've got a retainer letter that supports it, so a very logical next step. All the information regarding the retainer letter, including the risks, rewards of technologies and tools, the financial boundaries, the payment terms, client responsibilities, that's all done. Fantastic. And let's say there is a payment made towards that retainer, of course, supporting the receipt of that payment, a very important next step. Keeping you compliant, but also safeguarding the interest of your firm. Right? That's why we have the compliance. That's how it's been built out to be, because each compliance document, of course, narrates a story, a screenplay of the life cycle of a client and his or her matter or a business's matter within your legal firm. Conflict confirmation, depending on the nature of the matter, you could also have a conflict resolution documentation, which says there is a conflict, but this is how I will be addressing that conflict and still continuing to move forward with representing you, right? So that's a conflict resolution document. Source of contact, we spoke about that briefly. And then there's the non-engagement letter. And sometimes what happens is, given the nature of the matter itself, if this is a matter or a file that is going to be being executed over a period of time, so it's not a simple, let's say a POA matter, or maybe it's a small claims matter that has a tendency of a shorter duration. It could be a criminal matter that goes on forever. It could be a family matter that's extended over a length of time. Then the expectation is, let's say you're being audited in between that tenure. Then the question really comes, how have you corresponded back to the client, keeping them abreast of what is happening within that file? So whether that's the weekly, monthly, quarterly updates that you provide. If you're a business lawyer and you pretty much deal with the corporate houses, then that's a classic example of how do you correspond with these businesses on a periodic basis. Okay? So the client contact documents is really a combination of timely correspondence, keeping them abreast of what's happening in that file, and also ensuring that you keep them true to the expected responsibilities that the client has as agreed upon in the retainer or the engagement letter. And of course, once a matter is done, example, if let's say you're being audited and you have maybe 80 files, 30 of them have been closed, 50 are active, that's one of the first things that they would probably want to ask is, give me a list of all your active matters. And then give me a list of all the matters that you have. And then for the ones that have been closed, what is the documentation that you have to have a logical closure to that file? And this helps you too, right? Because if you do have the logical closure, then you pretty much can simply move on to the next matter. You can take this further to even say, are there any outstanding trust balances in that client's account? Because the Law Society does have guidelines around how long you can hold on to trust money. Because if it's been there for several years, then you are obligated as a legal firm to refund that retainer with that closure letter, or send back that money saying, this particular matter has been going on for about 8 years, and we really haven't moved forward, and with that being the pretext, here's where I refund the money that you provided, and here's a non-engagement letter saying, I don't think I can represent you further, or whatever the case may be. Right? So closure letter is an important completion compliance document. So these are some of the more important set of documents that an auditor is looking for when it comes to client management, client correspondence, extending it to file management, which is again regarding the client, of course, and completion and the closure to that file for that client. Okay, so moving along to my next slide. This is a slide that we introduced, of course, as part of our Everything Practice Management presentation. We've included this also in terms of the correspondence presentation that we've made. The importance of this slide, of course, is to quickly highlight that you as a legal firm have the power, based on the nature of the matter and the scope of the matter, to correspond and reach your client on a regular basis as determined or as needed based on the nature and scope of the matter. Okay? Of course, there are certain best practices recommendations made by the law societies. It's not mandated because you are in complete control and, of course, have full authority as to how often you have to correspond. It's important, though, to have, again, established the guidelines and the boundaries around how, when, how often you correspond with your client, so that your client is not taken, it's not pretty much at a surprise or does not know that really that happened. For example, if you say, I'm going to be emailing you, and let's say the client never checked your email, then they're going to probably expect you to have corresponded by phone or by email. Those are the types of things that you want to avoid by clearly establishing, saying in that retainer letter, hey, dear client, my preferred mode of correspondence is email. It's electronic. Here are the risks, rewards, and there's, to be very honest, there's cookie cutter documentation today that can be tweaked to better represent your nature. It needs to be reviewed and verified by yourself and your firm. But of course, you have enough help today to build these templates so that you're not writing this from scratch, right? So really the terms and conditions of that matter. So the Law Society definitely, depending on the nature and scope, does recommend at least a quarterly correspondence. Of course, if the nature and scope of matter is where it's a quick 2-week turnaround or 2 months, then you still follow the life cycle of everything we discussed in the previous slide till the closure letter. There are certain important documents such as the statement of accounts. Some cases you may even be required to provide the balances, trust balance, and a copy of all the invoices that you've rendered services for and been paid for, copies of all the retainer receipts, because having this information readily available, no matter what kind of system that you may be using, is very important. The bill of cost is another great example of a document that you maybe want to send to your client on a quarterly basis, because this really covers the total cost of the matter till that date, comparing, of course, both the legal fees as well as the disbursements, if any, in that particular matter till that date. A document that we at uLaw Practice often recommend to our clients is a aging document or invoice balance that pretty much tells you all the outstanding payments that you owe, or the clients rather owe you, so that it's easier now to correspond to them with an email that states, dear client, we've noticed that you have not paid us the X amount of dollars over a period of the last 60 days, and, depending on what you've signed up for, maybe there's an interest that's added to that or not. That's important. But not only is it a one-way street, this has to be a two-way street between the legal firm and the client. Once again, as I mentioned, it's the client's responsibility too to respect you as a business and as a profession, and to be able to pay you on time and, of course, handle their end of the bargain. So with the closure letter to the seasonal greetings that your firm can send your successful clients and clients that you've worked closely with, of course, helps with that branding experience for your clients and for your firm. Okay, so we've pretty much covered the initial section of client management, the client intake process, and the different paths that you take as the outcome of a conflict check, and all of the documents that both from a compliance standpoint as well as from a standpoint of your business that you would need to keep in mind and have a record of. Now, from a perspective of managing client information within your firm, especially if, let's say, you're a growing firm and there are many multiple individuals that are involved, we believe having the facility to tag or group your contacts is a very important process step that you could take within the firm to make it easier for search and retrieval of information. Of course, important categories that could be based on the nature of the matter, important categories that could be based on the, I would say, legal, the party type that they're in. So having plaintiffs, defendants, many such examples, right? Applicants, respondents, child, health practitioners, police officers. So it really comes down to the nature and scope of your work. This could also be vendors. So you as a business, of course, have vendors that you're regularly paying, whether it be disbursements that you're paying to the Ministry of Finance or the courthouse, or whether it's the business office expenses that you're paying, such as Walmart, Staples, etc. Managing contacts helps your firm, and further managing the contacts, especially around the client information and having the right group management around clients, is just going to make life easier for you to search and also have a quick glance over how many plaintiffs, defendants have you met with, right? And being able to use that information in additional parties so that your conflict searches are going to be that much more powerful. Managing ghost clients, which is a category where if someone were to come in, give you some, brief information about themselves and then disappear for a period of time, like a ghost, then you're pretty much stranded, not knowing what you should do with that. Those are the types of contacts and clients that you mark as a ghost client, send them a non-engagement letter, and move forward. Source of referral. That's another great group that you can create within your practice so that it's easier for you to reward those sources of referrals as well as use them in your source of contact report, giving you an idea of what marketing messages and what marketing avenues are working best for your firm and where you can invest so that you can make better returns of clients. So how do we handle a conflict check? An important immediate next step after you've done the client intake. Step one is really to, of course, to have had the prerequisite information of the client, first name, last name, correspondence address, any information that you can capture. Very important. It needs to begin with there. You need some fundamental starting point to be able to do that conflict check, right? Number two is, of course, figuring out who within your firm did that client intake form and the conflict check. If it's a single individual solo practice, then of course it's yourself. But if it's a large law firm, you really need to know who within the firm did that, what necessary steps did they take to determine the nature of that conflict check. Okay? Once that conflict check has been completed, it's important that that document be dated because you really need to know as of a certain date when you conducted that conflict search, that was the information that was used to base your decision of whether moving forward or not. So the Law Society definitely wants you to capture the date when that conflict search was done and who within your firm performed that search. Okay? We'll probably take a brief moment, of course, to give you a bit of a, I would say, a sidestep in terms of understanding your clients. There's, of course, a time and place for each of these types of nature of analytics. When you're just getting started as a firm, you're pretty much looking to generate revenue. You're really starting off fresh. You want to make sure that your expenses are low. And this happens over a period of time. You have expenses, you have revenue, and you're constantly working towards getting that revenue. And it could also happen to a seasoned law firm where revenue is king and you're always focusing your attention and your energy to pretty much bring the revenue. But there is a certain time, a lull period within a time frame, whether that's the weekend, month end, or quarterly time period, where you need to reflect upon who you are as a business, who are your clients, so that the next quarter you can either readjust or emphasize further on the success factors that have led you to where you are. So if you're really happy with where you are as a business, having grown over the last 3 months, then you need to know what's working for you, right? What are the areas of practice in which you have clients that provide you the fastest payment? I'm sure you would love to understand that information. What categories of areas of practice are my clients the most profitable? What areas of practice am I generating the most revenue? Which sources of contacts are relating or translating into clients? Which sources of contacts are mostly turning out to be non-engagements? These are the types of analytics and the questions that you probably should be asking yourself at a time that's more natural and meaningful to your firm, but definitely should be posting the questions and figuring out the answers so that now you can make informed strategic decisions about how best to grow your firm from where you are to the next step. Or if it's not working, of course, figuring out strategic steps to reduce the effect of a certain discipline or a certain way of how you're going about doing things. Or maybe reinvesting in a marketing strategy in a totally different area of practice. Okay, so another important documentation is if you are a firm that provides a lot of pro bono, okay, then really understanding at some point in time who are the recipients of these pro bonos. So the next time you're sending out a referral campaign, so an email that you send out to all your clients asking for referral leads, if you will, then you make sure that these pro bono clients are remembered so that when you send them that email, they remember it, and you can personalize that email as well. Of course, in doing all of this, there's a need to save time, there's a need to maximize the efficiencies, and there's many different ways of how you can go about addressing these needs that you as a client firm are imposed upon. You can do this manually. You can actually have external help, individuals who can help you. And then, of course, with today's technology and the advent of technology, you can use the right tools that can help you and come in handy to pretty much expedite the process, improve efficiencies, and still stay compliant all at the same time. And that's why choosing the right practice management, legal accounting tools can really help you in accomplishing all of those aspects. Okay? And of course, cost of ownership, that's very personal to each legal firm. But of course, you want to be able to do your own ROI on the cost, understand the actual cost of ownership, whichever route that you may take, understand the benefits of the route that you're taking, and of course, then committing to that route. So that's one of the most important things. It really does not matter what product you've chosen. What's really important is that you learn the use of that tool, technique, or process, manual or otherwise, and commit to training yourself, to training others in your firm to use that technique, tool, and process to maximize the benefit of that path you've chosen. You choose a product, never use it for 6 months, doesn't help anybody, right? So take the time to review what's best in the best interest of your firm, commit to it, maximize the benefits of that direction. Okay. So I'm going to take the next, 15 to 20 minutes, if you will, to really reflect and show you examples of these different types of documents that we're using. Of course, I'm using the ulawpractice tool. That's an example in this case. You can clearly see that I'm using uLaw as an example to articulate everything that we've spoken about around the client intake process and all of the documents. So within the uLaw product, of course, we have the segregation of contacts. We don't call them clients to begin with. It's really a contact management because you could have various different types of contacts within a legal firm. Now, there are different types of client intakes. Ours is a fairly simple one. You could have a legal firm that has different client intake forms for various different types of legal representation. You could have legal client intake forms that are more specific to the types of individuals in the firm. So you can certainly expand this in nature and scope depending on your current situation. But some of the most important pieces of information that needs to be captured include, of course, the name, okay? Now, many different pieces of information that you capture may be specific to the nature and scope of that matter. For example, certain court forms in certain styles of practice do ask for an AKA name, or also known as name. It's not relevant in every practice, but the legal practitioners who do practice and know those court forms pretty much know that AKA is a known name, right? It's a pretty important field that's being asked. So you can put that in. Certain court forms, such as family court forms, may ask you for the age of these individuals. So again, putting the birth date allows the tool, of course, to automatically calculate the age. Well, you don't have to do that. But I'll focus the attention on the source of contact. No matter what tool you use, as I mentioned earlier, an important consideration to keep in mind is to capture the source of contact, both from a law society's compliance standpoint as well as for your own firm's marketing standpoint. So whether that's Yahoo, or it's a walk-in, or it could have been just a referral, using that as an example, adding more information, referred by Gerald. Okay? And of course, if you do have the correspondence address, capturing that as well. You could capture phone number, website if it's a corporate company. And if it is a corporate client, of course, go ahead and make sure it's a corporate name, right? Or if it's an individual that you're representing, then by default, the client intake form allows you to capture all the first name, last name, all that. If there's an individual within a business that you're looking to correspond with, then of course that becomes a contact. So let's say you have to send this invoice within Rogers to a specific individual, Ian Smithsonian, then Ian is not your client really. Rogers is the client. Ian is just a party of type invoice to. So you store the information as a contact. The client really is Rogers, right? Let's say you do save that information in. If you go back to our presentation, one of the immediate next steps was to be able to do a conflict search before you even move forward with creating a file, right? Now, in this case, let's say if this individual, Mr. Ian, has given you this information, let's say this is an initial, like a 5-minute phone call, maybe a referral call from another friend, and Ian gave you all of this information, and let's say he became, he disappeared, he never corresponded or retained you for your service, then as I mentioned, it's important for you to then add him to the ghost clients, tag him, group him rather as a ghost client, so that you now have an appreciation for the type of contact that person is. He's not just a client, he's actually a ghost client because he's not a real client. But let's say you do the conflict check. This is the immediate next step that you have to take, that the Law Society expects you to as part of that client intake process. The client conflict search really looks at the entire database of your system with all the information that you've captured. If you've just gotten started, of course, you have a very fresh memory of who your clients are. Sometimes it's just a quick and easy appreciation of whether it's a conflict or not. But if you've been in business for a while, there could have been quite a few Ians that you may or others in your company may have met, and you may not always have a great memory of every first name, last name. And that's why the conflict search, being able to utilize a tool, this could be a simple Excel sheet where you have all the information, or it could be a online product that you can access at any time to help you through that process. But determining a tool that can relieve you of that manual search, of course, helps you and goes a long way. And if you look at the compliance documents we mentioned earlier, source of contact, let me quickly generate. Typically, the auditor may ask you for a year's information, saying, tell me over a period of this year, where have you got your clients from, or can you just generate the source of contact report for me? Before I get into the source of contact, let me open up a conflict search. You've got the first name, last name, the nickname, information about the client intake form, right? Then you have quite a few first names. Of course, this is a practice account that I'm using to walk you through this use case, if you will. And you can certainly notice there's quite a few, sounds like first name, last name conflicts. You have partial names that appear in previous matters, partial names that appears in certain dockets. So you as a firm would then make an informed decision. As I mentioned earlier, I think we should have the date. There you go. The conflict report was printed today's date, of course, giving you the confidence as to when this was done, right? So that's the conflict search that you conduct before you move on to creating the matter or creating a non-engagement letter. Now, the source of contact report, as you can clearly see, starts from the beginning of this year till date. You have almost 32% that you have tagged as others, or in this case, we have tagged it as others. But the next best is family, of 23% of your source of contacts coming from that. And because we captured this mostly for clients, you can also kind of assume that that's for clients. 18% coming from your Facebook advertisement, and an equal 6% from your Google and client referrals, right? And then you have this term of referrals, about 13%. Now, typically, if you have certain clients that have not been categorized, the auditor during an audit may actually ask you for their information and may recommend that you update that information. So one of the things that we do at uLaw, and you should find tools that can help you with that, or process and tools that can help you with that situation, is give you those reminders. Give you the piece of information such as Kim DeSouza, Johnny Deb, clients that have not yet either given you how they got to know your firm, or you failed to ask them at that point in time, and let's say you got it at a later time, you can always go back in, search up that information, right? Update that information so that you're always staying compliant. Because as a part of an audit, that might actually come back as a feedback, saying you have too many clients that you've not marked the source of contact for. So let's say you got to know that Johnny Depp was through a friend referral. Go ahead and save that information. Okay, so we've done the client intake, kind of walked you through what a conflict search looks like, and generated a few compliance documents. Let me go back to our friend Ian Smithsonian. Let's go ahead and create a file. As I mentioned, part of that whole process is also to manage the matter and files. Even if you were to non-engage that client at some time, you probably want to non-engage them for a specific nature and matter. So let's say this is an immigration file. Of course, when it comes to clients, you may have joint retainer situations where you can always add a joint retainer party so that when the documents are being prepared, it's being prepared in both names. It's as in the legal lingo, the joint retainer is a type of party. So let's say it was between Ian and his wife, Gloria Stepp. Adding Gloria as a joint retainer, of course, then allows you not only to facilitate that relationship for that specific file, but also, let's say, the next time another Gloria as a client walks into your office, you pretty much know the relationship that adds to the conflict search. Okay. And we looked at different documents. Of course, one of the first documents we look at is the retainer letter. Now you can, of course, look at different samples, different templates that best fit your firm's need, generate that retainer letter, but most definitely have the ability to amend it over a period of time, have important pieces of information captured within a retainer letter, which then, of course, varies from the nature and scope of the matter itself, right? But let's say you want to move ahead and you've done some due diligence and it looks like non-engagement is the route. You can, of course, generate non-engagement letters. Now, sometimes clients may offer a previously worked file and come to you, to your firm, and say, can you maybe review this matter and tell me if you could go ahead and engage with me? Then in which case you could go ahead and use a template which says client matter non-engagement after review. So let's say you've reviewed the file and you still want to non-engage. Of course, there's a different template for that as well. Let me open up the retainer letter for the PR application, because as I said, having the right tools gives you all these pre-populated, reduces the time and effort. But at the end of the day, you as a firm determine the final document that needs to be sent out to your client. So you may tweak this information, create this as a PDF, and email it. You may include email signatures, whatever additional pieces of information that you may be asking for as part of this retainer letter. Right? Maybe accepting a check as a retainer receipt along with the signed retainer agreement There you go. You could ask for a retainer before you start the work, really clearly articulating the termination guidelines or boundaries. And this is just another template. Communication, right? Our firm does use cloud-based programs, making sure that the client acknowledges that these programs have risks, rewards. And that's just an example of a retainer letter. Okay. A non-engagement letter, of course, you can put your letterhead logo. It clearly tells Mr. Ian Smithsonian that you are unable to represent them, and you're declining to undertake this matter. You sign this, date this, and correspond back. When we spoke about moving forward, so providing a retainer receipt, if let's say they did sign that retainer agreement. So all these are important pieces of documents. So let's say you did receive $1,000 check as part of that signed document, giving them that receipt. Again, you could email this, have this as part of the correspondence, have them sign it, send it back to you, have it uploaded into your practice management system. So it's all there in one place. You can have your own file management system within your laptop, your desktop. But importantly enough, it's to make sure that you have a process to be able to have this document available when being audited. So when the auditor does ask for a random file and asks you to show them, tell me the client intake process, tell me all of that, then making sure you have all that information available. With just a few more minutes left, just to give you a taste of some of these documents, we spoke about client ID verification. This is a document template that's provided by the Law Society. So if you search up the bookkeeping guidelines, as part of the bookkeeping guidelines, they provide you these templates. We've just tweaked it and made it easier for you to repurpose this information. It has all of that information captured. You could say I've captured the person's driver's license to validate it. Really, name of the legal professional who actually did the conflict search, right? And the firm's information. And there you have it. There's a client intake form that you can generate, and you can send this to your client, or you can show this to the auditor saying, this is the information that I've captured. Ian Smithsonian. And you can clearly see, even when there are parties involved, it shows you Smithsonian and Gloria, who are the two parties involved in this matter. Of course, let's assume you've done the work. Of course, you have to have a copy of all of the invoices. We're not going to get into that. But let's say you're closing this matter. And, of course, you have authorization letter, non-engagement letter, but a closing letter is a great example to show you, which pretty much articulates the work having been done. And now you're pretty much relieving yourself of any more duties because you've pretty much completed this matter for them. And you can always articulate what you've done to conclude this file. Right? Having this document signed and shared with your client. For certain types of matters, as we discussed, there's quarterly timeline documents to provide, for example, the statement of activities. Of course, in this matter, you don't have much of an activity except for that retainer letter. But if you were to imagine a use case of a matter where there's a lot of disbursements and, docketing, you would see all of that information there. Okay? So with that, I'll try and wrap today's webinar. Of course, going back to the most important component of today's webinar, which is for 1 hour of professionalism CPD credits, is really trying to highlight the importance of the client intake process and the importance of management of clients, the importance of all the documents that support the compliance nature of the process in your firm, both from an audit perspective as well as from a business management perspective. And pretty much giving you, throughout that workflow, the different types of documentation that is important to be not only stored, but also readily available when being audited, was really part of what the agenda was and really what part of this whole monologue has been for the past 1 hour. So I'd love to open the floor for any questions that you may have specific to today's webinar, or you can email us at support@ulawpractice.com with your comments, questions, and feedback, and we'll be more than happy to correspond back. And thank you once again for being part of this webinar. I would now open the floors. Please do use the chat window to ask any questions that you may have. Okay, yeah, if there aren't any more questions, I'm sure you'd find the time to email us. But please do email us at support@ulawpractice.com. This particular webinar presentation is being recorded and will be available on our YouTube channel as early as Monday next week. Please do subscribe to our channel to get more updates about the latest and greatest videos that we do provide and the CPD sessions that we offer. And I look forward to presenting another webinar to you next Friday at 2 p.m. So thank you very much, and have yourself a fantastic weekend ahead. Thank you.